Welcome to Foley and Lardner Web Conference Program concerning the new Consumer Financial Protection Bureau. Today's program will be led by Mike Luder, who chairs the firm Consumer Financial Services Litigation Practice. Mr. Luder, you may begin when ready.
Hello, everyone. Thank you for joining us today on this designated transfer date for the Consumer Financial Protection Bureau. My name is Mike Luder. I'm the chair of Foley and Lardner's Consumer Financial Services Litigation Practice Group, and I'm a partner in our Milwaukee office. As I'm sure you all noticed and heard, this Consumer Financial Protection Bureau has many people talking about it, and President Obama's recent nomination of Richard Cordray on Monday was big news. He announced to head the Bureau, and that certainly answered one of the major questions surrounding the new agency, but many, many questions remain, and our presentation today is devoted to answering other important questions while also raising some that are yet to be resolved. Our presenters today include members of our practice from Chicago, Madison, and Milwaukee. First speaker is Marty Bishop. Marty is a partner in our Chicago office. He's the vice chair of our Consumer Financial Services Practice Group and writes extensively about the CFPB. Marty will discuss the Bureau, its new leadership, and the statutory timeline that we can expect for the next couple of years. I will then focus on a bunch of basically hodgepodge issues, including Professor Warren's recent testimony, the CFPB's plan for supervising banks, and preemption. Tim Crisp is also a member of our group. He's a consumer compliance lawyer out of our Madison office. Tim will address the current and prospective rules working their way through the Bureau. I have a couple of instructions here for our listeners. First off, we know from the past that many of you like to print out the hard copy of the PowerPoint presentation and then use it for note-taking. You can print that out by clicking on the printer icon towards the right-hand end of the bottom of the border of the screen. And you can submit questions to us via email using the Q&A function on your screen. We'll address them at the end of the program if we have time. If not, we'll follow up directly with you. So if everybody's ready to go and get started, let's get started. I'll turn it over to Marty.
Thanks, Mike. Hello, everyone. Thanks for joining us today. It's a real pleasure to have the opportunity to speak with you. Let me be the first to wish you a happy designated transfer date. Today is the day selected by the Secretary of the Treasury, Tim Geithner, about a year ago to transfer to the new Consumer Financial Protection Bureau all the major functions and new powers granted to the Bureau under Title 10 of the Dodd-Frank Act. On top of that, the Bureau is officially open for business today. Practically speaking, today is not, I don't think, a whole lot different than it was yesterday. As you know, if you've been following along for the past year or so, the Bureau has been very active. Over the course of this hour, all three of us will be covering the Bureau's various activities over the past year, and we'll attempt to plot the Bureau's likely course over the coming months and years. What I will talk about specifically is first a brief overview of your new regulator, and looking at the attendee list with the exception of a few stray law firm lawyers and regulators in the crowd, I believe that all of you work for a covered person under Title 10, which means you'll be regulated by the Bureau in one way or a myriad of ways. So I'll spend a couple minutes talking about your new regulator. Next, I'll spend some time introducing you to a few of the Bureau's leaders. And finally, I'll take a few minutes to give you a sense of, to look at what the Bureau is statutorily required to do, I guess, over the next couple of years, to give you a sense of what is expected from the Bureau in terms of policy developments.
Marty, let me interrupt you for a minute. We just received a question from someone that says the phone number given to call in is not correct and just wanted someone to know. So, John Vickers, will you please investigate that and make sure that folks are able to call in? Sorry about that. Go ahead, Marty.
Okay. What is the Bureau? It calls itself the cop on the beat, and I think Mike's going to talk about that a little bit in a minute. You'll hear it called and referred to as the CFPB. I like to call it the Bureau, and I'll talk about the reason why a little bit more in a minute. But whatever you call it, you need to understand that it's your new regulator. If you had a regulator before, you have a new one today, and if you didn't have a regulator before, welcome to the party, so to speak. At this point, I had hoped that we could show you the Bureau's internet video where in cartoon form it portrays the mortgage and other financial services companies as bad guys and itself as the protector. Unfortunately, we couldn't make that happen from a technology standpoint. But if you go to the website listed there, consumerfinance.gov, and click on the Bureau, a video will pop up entitled, Welcome to the Consumer Financial Protection Bureau. Feel free to go there now and amuse yourselves as I talk. I'll send each of you the link after the session so you can peruse at your leisure. I'll also include in that email a report that was issued by the Bureau this past Monday, which is a quick but really a very interesting and insightful read. The first image you'll see on the website and video is a badge, the badge that's up there on the screen with the letter CFPB on it, hovering over and illuminating what is, portended to be a financial district. This Bureau, this regulator, is not your grandfather's or probably even your father's financial services regulator. A few things I noticed right off the bat and encourage you to watch out for when you watch the video. First, the badge. Your regulator likes to think of itself as carrying a badge, and like Commissioner Gordon shining a light over Gotham City, the Bureau has sweeping lights of justice focused on the mortgage and consumer financial services industry. Second, the agency rarely refers to itself as the Bureau. It calls itself the CFPB. Don't be fooled, though. This is an investigatory and enforcement bureau for consumer financial products, just like the Federal Bureau of Investigations is an investigatory and enforcement bureau for crimes. Third, and what I think is sort of astounding, is the Bureau looks at your products and services as if they were toasters. Consumers, you see, need to be protected from any bad toasters you might be producing. And toasters and credit products are, after all, the same thing, right? Well, the Bureau thinks they are, and it is going to try to prevent you from electrocuting consumers in the bathtub with your unsafe credit cards and mortgages. Finally, this regulator is devoted to using social media to oversee its constituency. The Bureau has a blog, a Facebook page, a Twitter account. The Bureau will take suggestions from consumers about how to regulate you and your products via YouTube. On top of that, top-level officials in the Bureau are regularly tweeting, publishing videos, blogs, articles that are designed, it would seem, to gain the favor of a constituency. This is subtle, but I think pretty effective techniques at persuading the masses or consumers really, that financial services companies should be viewed with some level of skepticism, almost as if we are all nefarious figures of some shadowy underbelly of society. I'm exaggerating slightly, of course. The Bureau is certainly not all bad news for us. I was reading an article this morning in which Scott Talbot, the chief lobbyist for the Financial Services Roundtable, was quoted as saying it's all good, and the industry supports what the CFPB is doing. So there you go. Who's going to lead this new behemoth? Well, we don't know for sure yet. Elizabeth Warren is out and may be pursuing a seat in Congress. On Monday, as Mike mentioned, President Obama nominated Richard Cordray to be the Bureau's first director, but the President either needs to get the Senate behind him on this or make a recess appointment in August. The Senate is somewhat problematic because 44 Republican senators are on record and have sent the President a letter stating that they will not confirm anyone unless and until the Bureau's powers and funding are restructured. A recess appointment, although potentially wrought with political pitfalls, is probably more likely, I think. I just can't see this President letting the Bureau go forward without a director at this point. If he makes a recess appointment of Cordray, it means that he will fill the seat for at least 16 months, which would bring us to the end of the next session of Congress. At that time, the Senate must either approve him or the position becomes vacant again. And Mike is going to talk about this with you a little bit more in a few minutes. So who is he? Who is Mr. Cordray? The Wall Street Journal described him as Mrs. Warren without the charm. He is a former Attorney General of Ohio and previously held a seat in the Ohio State Legislature. He's a very smart guy. He's a lawyer. He graduated from the University of Chicago. He was the editor-in-chief of the Law Review there. He clerked for Justices Byron White and Anthony Kennedy on the Supreme Court, and is a 5-time Jeopardy champion. One of the more interesting things about Mr. Cordray to me is that he has a famous doppelganger, Kenneth from 30 Rock. Next time you watch 30 Rock, I defy you to distinguish the two from a physical perspective. That is probably where any fair comparison of the two would end, though. One of the adjectives most commonly associated with Mr. Cordray is in the consumer protection context is aggressive, and you'll never see that word if you watch 30 Rock associated with Kenneth. That being said, as far as I know, these two have never been in the same room together. All kidding aside, well, Mr. Cordray is not Elizabeth Warren. I'm not sure that is good news for most of you. He's a zealous pro-consumer advocate. He was a leader on the robo-signing front and has historically had political aspirations of his own. We'll delve into his history on that score a little bit more in a minute. Several other key positions at the Bureau have been filled, I think all of them now. These are a few. Unlike the director, none of these folks have to be appointed by the president or confirmed by Congress. Instead, everybody listed up there was hand-selected by Elizabeth Warren to serve. Stephen Antonakis comes from Massachusetts, where he was the Commissioner of Banks. He has extensive experience in bank supervision and will serve as the Bureau's Assistant Director for Large Bank Supervision. Leonard Shannon is the Bureau's Assistant Director for Regulations. He was the Deputy Director of the Fed's Division of Consumer and Community Affairs. Raj Date has been working at the Bureau as one of Warren's, up to this point, as one of Warren's deputies. He worked formerly as a banker with Capital One and Deutsche Bank. Earlier this month, there were significant rumors that Date may leapfrog Warren as the director. The argument for Date was that he provided a good compromise on the nomination. Progressives would be happy the argument went because Date is favored by Warren, and the consumer financial industry could rest a little easier, the other argument went, knowing that Date was a former banker with Wall Street experience. That's not going to happen, though, it looks like. Instead, he will serve as the Associate Director of Research, Markets, and Regulations. Interestingly, he is a former director of Prosper Marketplace, which is a peer-to-peer online lender for consumers, and in its first 4 months of operation, 4 years, excuse me, reportedly 25% of the loans Prosper arranged went into default. Patricia McCoy is a law professor at the University of Connecticut and a former partner at Mayer Brown. She's testified before Congress about consumer finance issues and has written several of the Know Before You Owe pieces posted on the Bureau's website. McCoy is now the Assistant Director for Mortgage and Home Equity Markets at the Bureau. David Silberman is heading the Bureau unit that will research and write the new credit card rules. His official title is Assistant Director for Card and Prepaid Markets. Silberman is formerly of the Kessler Group, which is a Boston-based consulting firm where he headed up the insurance business. He's also the former General Counsel, President, and CEO of Union Privilege. That's the benefits arm of the AFL-CIO. When he was the GC there in the early 90s, he negotiated the first agreements with credit card issuers to create affinity cards for union members. Peggy Tuig is the Assistant Director for Non-Bank Supervision and is charged with setting up supervision of non-depository financial companies. Tuig previously ran the Department of Treasury's Office of Consumer Protection. Her stated goal is to subject non-banks to the same kind of supervision that banks have been subject to historically. Again, not a good sign for those of you that could fall within these new supervisory powers under Title X, which Tim and Mike, I think, are going to talk about in some more substantive detail in a few minutes. Finally, Elizabeth Vail, who has been the Executive Director of the White House Business Council, was a managing director at Morgan Stanley and a portfolio manager at Philadelphia National Bank, is now the assistant director for community banks and credit unions. I'm going to spend the remainder of my time going over some of the deadlines and specific things that the Dodd-Frank Act requires the Bureau to complete subsequent to today, the designated transfer date. For the most part, the statutory deadlines end 2 years from today. There are 4 statutory clocks, if you will, that start ticking today and end respectively in 90 days, 6 months, 1 year, and 2 years. Each of these clocks have several components that, if you look at them collectively, illuminate at least part of the path the Bureau is likely to take in terms of policy and regulatory initiatives for the foreseeable future. So let's just jump right into it. Mike is going to interject a little controversy on this point in a little bit, but as I mentioned, today is the day that all of Title X becomes effective. Some parts of Title X, as you probably know, have been effective for some time. But among the most significant new provisions affecting all of you are the Bureau's ability to supervise your conduct and to bring enforcement actions to address alleged violations of the various consumer protection statutes. In addition, the Bureau has a big new power in its statutory mandate to protect consumers from unfair, deceptive, or abusive acts or practices. UDAP, as distinguished from the FTC Act's UDAP, is probably the biggest compliance issue most of you will face in the early years of the Bureau. It's an area that is rife with landmines, and anyone that I have talked to about UDAP is deeply concerned about its potential implications. It's really a topic unto its own. I've devoted, and I know a lot of others have, devoted a significant amount of time to the subject, and I expect that we here at Foley will be announcing a webinar devoted to UDAP and its compliance implications in the next week or so, and I would strongly urge you to attend that and start thinking about this. And let me just digress a little bit into UDAP here. In late 2009, the then Attorney General for Ohio, Richard Cordray, filed complaints against 3 mortgage servicers alleging various violations of Ohio's state UDAP law, and these were directed at, I'm quoting here from the complaint, inadequate, incompetent, and inefficient handling of complaints, inquiries, disputes, and requests for information and assistance. Close quote. At the time of the suit, there were no standards on the books, of course, at the state or the federal level, for that matter, regarding what constitutes adequate, competent, or efficient handling of complaints in the mortgage servicing context. Among a host of issues directed at alleged unfairness and deception, the complaints raised the question of whether certain loan modification terms are unfair and whether customer service call wait times above a certain threshold are unfair. I think that these complaints illustrate some of the new directions the Bureau might take under the new UDAP law. In a press release issued at the time these complaints were filed, Cordray condemned mortgage servicers for not strengthening their efforts and making a significant difference, and I'm quoting from the press release, in preventing home foreclosures. He also criticized mortgage servicers for making excuses for not taking more aggressive action to stop foreclosures. Just some food for thought. My humble opinion is that this was an aggressive use of UDAP, and yet is nonetheless telling about the type of approach the Bureau will take with UDAP with 2 A's going forward. The last big thing that happens today is that the Bureau gets all of its money. All the table pounding in Congress has done nothing to stop Title X statutory requirement of automatically funding the Bureau straight out of the Fed's budget. Okay, let's spend the next 5 minutes or so whizzing through the rest of this timeline. What should we expect 90 days from now? 2 things. First, the Bureau is required to have a private education loan ombudsman who will enter into a memorandum of understanding with the student loan ombudsman required under the Higher Education Act. The goal here is to ensure the coordination of assistance of borrowers seeking to resolve disputes regarding their private education or federal student loans. Student borrowing is a pretty high priority for the Bureau. Second, the Bureau is taking employees from other federal agencies that prior to today had responsibility for various aspects of oversight of the consumer financial services industry. No later than 90 days from today, the transferor agencies must transfer all the employees that are to be transferred to the Bureau. No later than 6 months from now, the Bureau has to accomplish 4 things. First, the Bureau is required to appoint an ombudsman, another one who must act as a liaison between the Bureau and anyone who has an issue resulting from the Bureau's regulatory activities, and also to assure that the agency maintains a safe, encouraging, and confidential environment for complainants to come forward. Second, the Bureau must establish the Office of Financial Protection for Older Americans, which will facilitate has a goal of facilitating the financial literacy of seniors who have reached 62 years of age or older. The literacy initiative must include protection from UDAP. Third, the Attorney General and the Bureau must coordinate investigations and proceedings, and by this time have negotiated an agreement for such coordination. Finally, within the 6-month period of time, the FTC and the Bureau are required to reach an agreement for coordinating enforcement actions. This most certainly will have implications on UDAP as well. The next interval is 1 year from today, when the Bureau must have established the Office of Fair Lending and Equal Opportunity, the Office of Financial Education, and the Office of Service Member Affairs. As you may know, a lot of this work has been done or is well on its way to being completed. Also within the next year, the Bureau is required to issue a rule defining covered persons who are larger participants of a market for other consumer financial products or services. The Bureau is required here to consult with the FTC on the rule, and recently started taking comments from its website on who should fall within this definition. That is the definition of a larger participant, and Tim is going to give you quite a bit of detail on this later. The Bureau must also develop and propose for public comment model disclosures for mortgages. The disclosures have to combine the required TILA disclosures and the Section 4 and 5 disclosures required by RESPA. Tim is also going to talk about that in some detail. As you might know, the Bureau is well on its way to accomplishing this. Also within the next year, the Bureau has to conduct a study on reverse mortgage transactions. And finally, by this date next year, the Bureau has to submit a report to Congress describing any new recommended legislation and updated regulations directed at protecting consumers from exchange facilitators for those transactions that are primarily for personal, family, or household purposes. Within the next 2 years, the Bureau's Office of Financial Education, through that office, the director, assuming we have one, is required to submit its first annual report on its financial literacy activities and its strategy to improve consumer financial literacy overall. The annual report goes to the Senate Banking Committee and the House's Financial Services Committee. Additionally, the Bureau is tasked with monitoring the risk presented to consumers by consumer financial products and services. Beginning 2 years after today, the Bureau must publish at least one report a year detailing the quote-unquote significant findings of its monitoring activities. And finally, the protection from pay decreases and voluntary separation and involuntary reassignment afforded employees that are transferred from transferor agencies under this transition expires 2 years from today. So what's the takeaway? By the end of this 2-year timeline, the Bureau will be in a position where it will have essentially complete coverage over consumer-facing financial products and services. And as these deadlines suggest, and as the Bureau is not bashful about saying publicly, it will demand from our side of the industry transparency and clear disclosures in product terms. And I think it's safe to say that if we fall short of statutory or Bureau standards, expect Richard Cordray, if he's appointed, and the Bureau certainly in his stead to hold us responsible. With that, I will turn the microphone back over to Mike.
Thanks, Marty. So as Marty said, on Monday, President Obama nominated Richard Cordray to serve as our new director for the CFPB. However, it does seem very, very unlikely that he's not going to be the confirmed director anytime soon. On May 5th of this year, 44 U.S. senators sent President Obama a letter saying that they will not confirm any nominee, regardless of party affiliation, to be the director without significant changes to the organization. And here's what they say they need. One, they want the Bureau to have a board of directors, just like the Federal Reserve Board has and the Securities and Exchange Commission and the FDIC have. None of this one director business for the Republicans. They would like something more like a commission, probably of 5, where you have bipartisan representation. Number 2, they want to subject the Consumer Financial Protection Bureau to the appropriations process. In other words, they want congressional oversight over the budget. Right now, as Marty mentioned, the funding just comes from 10% of the Federal Reserve's budget. It's automatic, and then increases over the next couple of years. Finally, they want to establish and are requiring that that safety and soundness check is from the prudential regulators is put in place. The idea here, I think, is that federal bank regulators would be given meaningful tools to prevent the CFPB from issuing regulations that would needlessly cause bank failures. So, as we note, absent a recess appointment type situation, we don't think we're going to have a director of this agency for a long time. And that means really, if Obama nominated Ann Coulter to be the head of the organization, no go. If he nominated J.P. Morgan Chase CEO Jamie Dimon, no go. George Bush would not be an appropriate director. No one will be confirmed as director. It doesn't matter who's nominated until this is changed per 44 of the Senate Republicans. So what does that mean? It has consequences. There are some things the Consumer Financial Protection Bureau can do without a director, but there are also things that it is not allowed to do without a director, or at least that's what many will argue. Many believe and will argue that the CFPB can only exercise those powers that were transferred to it from other governmental agencies. Dodd-Frank contains 2 relevant provisions here. The first, Section 1066A, gives the Treasury Department interim authority to exercise those powers which transfer to the CFPB from other agencies until a director is confirmed by the Senate. So transfer date is not material for this authority. It's whenever a director is confirmed, that's when Treasury loses its interim authority to exercise powers transferred from other federal agencies. So that would include things like, and these are things they can do right now, rulemaking authority on core enumerated consumer laws that transfer to the CFPB. And those transfers, as you know, come from the Fed, the OCC, the OTS, the FDIC, and the credit union organization. The second thing that the CFPB can do without a director is examine, supervise, and enforce laws related to large depository institutions. These are the 2 main powers that they can start exercising today. Not under Treasury authority, but just their own authority because that interim authority from Treasury will be transferred to them by the Treasury Secretary. Now, in addition to the transferred functions that are outlined in Title 10, the Consumer Financial Protection Act also established new federal consumer financial regulatory authority that has never, ever been held by any federal regulatory body. Under the CFPA, that is the Act, the Secretary's power to exercise this authority expires today. So if the Bureau does not have a new director, a Senate-confirmed director, many will argue that there is no authority to exercise any of the newly created powers. So let's look at what that is. These newly created powers, the authorities that requires a director, include things like examining, supervising, enforcing laws against non-depository institutions, non-banks, like payday lenders, mortgage brokers, foreclosure relief providers, student loan providers, just that group of non-depository institutions that everyone at the time of the passage of Dodd-Frank, thought it was important to get some kind of federal regulation. Also, the power to prohibit unfair, deceptive, and abusive acts or practices. That's a new concept. That's just new in Dodd-Frank. Certainly the abusive part is. And question as to whether they have the ability to make enforcement actions or issue rules related to this particular new concept. Also, many will say that they are not permitted to issue model disclosure forms and issue certain rules under some new authority, or under certain statutes. So it's not really clear that the CFPB can do everything that's Dodd-Frank envisioned without a director, and I think what we'll see is they will have some limitations before they take action in these areas that I have on this slide. Now, even though a director will not be confirmed anytime soon, we should know that there are 400 new cops on the beat from the financial services industry, private law firms, the regulatory community, the consumer advocate community, academia. And these people are all going to start supervising and examining beginning today. And they're going to be looking for things to do. These are highly compensated folks. They are off the government pay scale. The CFPB's website has a lot of job openings. I think they all closed today, actually. But you can see what the salaries are that are being offered. Salaries for examiners can be over $200,000. Not your typical government compensation. Now, putting aside for a minute what powers can and cannot be exercised, let's turn to what we think that the CFPB will do first. First off, last week, Elizabeth Warren, for I think the third time, testified before Congress, this time before the House Government Oversight Committee. And during the testimony, it's a 3-hour session, and most of it's taken up by congressmen giving speeches. But as far as the substantive testimony, Professor Warren was asked many times, several occasions, whether either she or the CFPB had any particular financial product in mind that should be eliminated. Now, to give you some backstory here, Professor Warren has written lots and lots of articles about how terrible certain payday loan practices were, or things that she identified as predatory lending, basically bad acts in the financial world. Nonetheless, despite previous writings, she was unable to identify a single financial product that she thought should be eliminated. She was pressed, and this question was asked of her many different ways, but it's clear that, at least in her mind, there isn't some product that they are itching to do away with when the doors open. She also provided that the CFPB's focus is going to be on forms and making forms easier, in her words, fairer and more effective to use. She said, the fine print's the problem, long disclosures are the problem, so I think we can expect any initial regulations to focus on disclosure rather than on product bans. Now, although it was not specifically addressed in her recent testimony, I think one thing that probably might be on everyone's mind is arbitration. Arbitration is a hot topic, as we've just seen a very favorable case for the industry in the AT&T mobility case on arbitration, and basically upholding arbitration in consumer contracts at the Supreme Court. Well, one of the specific charges for the CFPB in the Dodd-Frank statute is to issue a report to Congress that addresses mandatory pre-dispute arbitration for resolving consumer complaints about financial products. The report, we expect, will probably be negative about arbitration in the consumer context, and then based on those findings, it's very possible that the CFPB could undo the AT&T mobility case as it relates to consumer financial products. they would be acting arguably on congressional authority to do that. So we may not see those that case have much strength once the CFPB does its work. We shall see what happens. Next, I'd like to turn for a minute to the CFPB's bank supervisory approach. This is something that they've recently announced. They put a lot of disclosures on the website. You can go to it and you can find all kinds of information about what they intend to do. But one thing they do, and they say all the time, they say it on the website, they say it on Facebook, they say it on Twitter, they say it in their congressional testimony, and that is the CFPB is going to be the cop on the beat. We're the cop on the beat. It's something that Elizabeth Warren says continually. I'm sure Mr. Cordray probably uses the same terminology and thinks about it that way. And as we all know, the CFPB will supervise 111 depository institutions that have assets over $10 billion in assets. That just happens to be the number of such institutions in the United States right now, but anybody with over $10 billion in assets will be subject to direct supervision from the CFPB. The CFPB has announced that it will have satellite offices in Chicago, New York, San Francisco, and Washington, D.C., and a large part of the staff will be transferred from other governmental agencies, and as we discussed, many new hires have already occurred. And we expect that most of those 111 financial institutions are going to get periodic examinations. But the biggest organizations, the most complex organizations, will get year-round supervision. So today, if your company has a constant OCC presence in your organization, they have an office at your business, you should expect the same thing from the CFPB. Literally today, the CFPB will reach out to establish channels of communication and introduce each bank to the agency's supervisory and exam process. The CFPB will also post, I think this is very significant, so I'm going to say it twice. They're also going to post on their website a field guide for examiners supervising both banks and non-banks. I intend to use this guide as a CFPB investigation roadmap, and you should too. So let me say this again. Soon, I don't think they have it up yet. I looked for it about an hour ago, and I don't think it's there yet. They will publish a field guide for their examiners, basically what to look for when they go into banks and non-banks, and that should provide you with a roadmap of what you're going to see from these folks when they come and examine your company. So please do watch for that and look for that, because I think it will be very helpful to you when you are confronted with a CFPB investigation. The next topic I'd like to discuss is one near and dear to my heart, and that's preemption. Let's talk a minute about what Dodd-Frank did and where we are today with respect to preemption. Under Dodd-Frank, the OCC was stripped of a lot of its ability to make sweeping preemption determinations. Now, while Dodd-Frank basically was a brushback pitch, if you will, to the OCC, the OCC still remains the exclusive agency empowered to make preemption determinations under the National Bank Act. And frankly, recent indications are that they have every intention of continuing to use that power. So if you think about let's talk about the preemption rules of 2004. If you recall, these rules announced broad sweeping preemption in both loan making and deposit taking. Many considered these rules to be an improper exercise of OCC power. They have essentially provided for preemption of any state law that touched on a national bank activity. And most courts, though, determined that the OCC, in fact, did have the power to make that announcement, to issue the preemption rules. And most courts accepted its detailed list of incidental powers to find preemption of various state laws that attempted to regulate banks or banking. As we and others have discussed in prior presentations, the CFPA, the Act, or Dodd-Frank, was seen as basically requiring a major shift in both OCC and court behavior. So if we recap it for a minute, this is basically what we had with Dodd-Frank. The OCC now was going to be required to make preemption determinations on a case-by-case basis. The OCC decisions had to come from the comptroller, him or herself. The determinations were not delegable. That meant that no authoritative interpretive letters from the OCC's General Counsel's office could come anymore. It had to come from the controller. To make sure, I think, that the OCC did not overstep its bounds, Congress required it to publish an update each quarter, its list of preemption determinations, and to identify the activities and practices covered by each determination. Then, if that weren't enough, every 5 years, the OCC is required to go through a notice and public comment process to examine all of its preemption determinations. Clearly, Congress's purpose here was to create basically a hassle factor for the OCC in issuing preemption rules. They went on to tell federal courts how to evaluate them, saying not entitled to Chevron deference anymore. So one would say, okay, well, what happens to the 2004 preemption rules that were relied on by so many courts and by banks and by regulators? Well, they weren't specifically overturned in the statute. They were not withdrawn by the OCC. The President didn't strike them down. Some have argued that the requirement that preemption decisions be made on a case-by-case basis undercut the continued viability of the preemption rules. But as we have recently learned, that is not the OCC's position. Yesterday, on July 20th, the OCC issued its final preemption rule. And this rule was subject to notice and comment. It was first published, I think, in May, and then the comment period, I think, closed at the end of June. They got lots of comments, including one from the Department of Treasury, which said that, you know, your initial draft here is not the intent of Dodd-Frank, and you're wrong, basically. And they did take some of those comments to heart. What we have now is a new rule that I think does many of the things that you would expect. First off, sorry, I got behind in my slides here. First thing that the rule does, it applies existing preemption standards under the National Bank Act to federal thrifts. Okay, so that's not a big thing that was expressed in the statute. It also repeals preemption protection for non-federally chartered subsidiaries, agents, and affiliates. Remember, that's the essentially the congressional provision that overruled the Waters Supreme Court case. They codify the Cuomo versus Clearinghouse case, the Supreme Court case, to provide that a state attorney general can bring actions to enforce applicable state laws against national banks. The rule originally, in the proposed rule, used the term non-preempted state law, and in response to comments, that word was changed to applicable state laws. It also attempts to clarify, and this is the big deal, I think, it also attempts to clarify its 2004 preemption rules by removing the current language, quote, obstruct, impair, or condition language of the preemption rules on real estate lending, non-real estate lending, and deposit taking. If you remember, that was probably one of the more controversial parts of the rules because these words were viewed as creating or attempting to create essentially field preemption, and that was what Congress was trying to address, I think, when they gave this brushback pitch. Dodd-Frank, what the new rule says is that Dodd-Frank does not create a new standalone, quote, prevent and significantly interferes, end quote, preemption standard. If you recall, that's the language that's used in the Barnett Bank case. And there are some folks that were arguing that those words are the new standard. Rather, what the OCC says is that we are going to merely incorporate, and what the statute means to do is to incorporate conflict preemption the conflict preemption legal standard and reasoning that supports it from the Barnett Bank decision. So in other words, rather than picking out just a few words from Barnett Bank, all Barnett Bank and the adoption of Barnett Bank does is say conflict preemption applies and look at the whole decision to do your analysis. So where does that leave us with respect to the existing case law and regulations that are consistent with Barnett Bank? Well, what OCC says is that those cases, that case law, those regulations are preserved. To the extent things are consistent with Barnett Bank, there's no change required by Dodd-Frank. In a nod to the commentators, the OCC went on to say only cases based exclusively on the obstruct, impair, and condition language of the preemption rules must be reexamined. So all of this reexamining, as you might imagine, is going to be a massive, huge legal fight. It's going to result in lots of different district court decisions, lots of different Court of Appeals decisions will be battled out in the courts for years to come, and ultimately will go to the Supreme Court probably sometime in like 2015 or something. So lots of uncertainty over this issue, and there will continue to be uncertainty. Good thing for counsel that represents banks, and good thing for banks, I think, is that we still have arrows in our quiver to say about preemption in the face of either individual or class lawsuits brought on the basis of some state law that we think doesn't apply to a bank. Now, there aren't very many cases on this issue yet, as you might guess. However, as this just went into effect today, but there is one case that was decided in May that I think is pretty interesting, and that is the Baptista versus J.P. Morgan case. In that case, Chase Bank charged Baptista a fee to cash a check. He was not an account holder of Chase. He wasn't a customer, so he got like a $6 fee for the service of cashing his check. Baptista then filed a class action stating that the charging of the check cash fee violated Florida law. The 11th Circuit found preemption. It said that Dodd-Frank had settled the issue on preemption, stating that conflict preemption applied. It then went on to rely on the 2004 preemption rules from the OCC to find that the Florida law created an irreconcilable conflict with the National Bank Act because the OCC had specifically allowed for the charging of such fees. Now, the 11th Circuit did not appear to recognize any change, really, on what I would view, though, kind of the more recent last decade preemption standards coming from Dodd-Frank. Now, granted, Dodd-Frank wasn't applicable on this point yet, but they mentioned Dodd-Frank, but not make the decision based on any issue with respect to whether the new pronouncements in Dodd-Frank applied. They simply mentioned Dodd-Frank, applied what they saw as a Dodd-Frank standard, said it's conflict preemption, and said the OCC told us in 2004 you can't regulate these fee states, and that's what they went off on. So I see this as a very encouraging case from our future arguments on preemption. In another case, another recent case from late last month, the Middle District of Florida reviewed the preemption rule to find no preemption of debt collector laws of general applicability. It gave no mention of Dodd-Frank, but because the Dodd-Frank preemption provisions are effective today, courts making decisions prior today may not have felt the need to comment. But for the last year, we know, for the last year at least, courts have certainly been on notice from Congress that many thought that the OCC may have gone too far with its preemption rules, and as best we can tell, that has not had a significant impact in court, at least not yet. We will see where this all goes, but as I say, I think another trip to the Supreme Court is to be expected. So as I said, it was a hodgepodge, and I'd like now to turn this over to Tim Crisp. Tim just published today an article on our blog, and I'd like to do a little plug for the blog before turning this over. The Consumer Financial, it's the Consumer Financial Services Litigation Bulletin is the name of the blog. It's the acronym, actually, Bulletin, and you can find it on the web. And we publish there regularly, publish on this topic all the time, and we hope you find it useful. And with that, I'd like to turn it over to Tim Crisp.
Thank you, Mike. And the web address for that blog, by the way, is cfslbulletin.com. I'm going to be talking about what this new infant startup agency, it's been referred to by Professor Warren as a startup, and they have been starting up, what they will be doing in terms of rulemaking. Rulemaking, of course, being really one of the three topical things that the Bureau will be doing. Rulemaking is, of course, making law and kind of putting the fine points on acts that Congress passed and the President signs into law. And giving interpretations. The other ones, of course, being supervision and examination and enforcement. The rulemaking activity that has happened to date has been relatively sparse. It took them a while to get funding to get some of these initiatives underway, but they have started recently publishing some notices in the Federal Register that we'll be talking about, and I'll be talking about some prospective rulemaking that we're fairly certain will be coming down the road more or less sooner than later. There was a notice that established the designated transfer data to date. That was published last year. There's a rule that was just issued today in a final rule form identifying enforceable rules and orders of other agencies that the Bureau will be taking on, and in addition to the statutes that Congress gave it authority over in the Dodd-Frank Act. And then there was a notice and request for comment on defining who is a larger participant in certain consumer financial products and services markets. On the identification of enforceable rules and orders, again, that was published today. It goes into effect, I believe, next month is the effective date, and it was compiled in accordance with the Dodd-Frank Act after consultation with the transferor agencies, those being primarily the existing banking regulators, the Office of the Controller of the Currency, the Office of Thrift Supervision, which, by the way, went out of existence today. Its functions being taken over by the OCC, the National Credit Union Administration, the Federal Deposit Insurance Corporation, and then the FDIC. In the final rule on those rules that will be enforced by the CFPB are some pretty big ones. A lot of Federal Reserve Board regulations dealing with equal credit opportunity, non-discrimination covered in that, home mortgage disclosures, electronic funds transfers, residential home mortgage loan origination, consumer leasing, privacy, consumer financial privacy, fair credit reporting, truth in lending, and truth in savings. It also took over enforcement of certain OCC, OTS, and NCUA rules on certain adjustable rate mortgages, and a number of Federal Trade Commission rules, including telemarketing sales, rules on disclosures for depository institutions without deposit insurance, the Mortgage Assistance Relief Services rule, the pre-notification negative option plan rule, the cooling off period for home sales, the holder in due course rule that says the transferees of obligations can't assert holder in due course status, that they remain subject to defenses that the consumer has, certain unfair credit practice rules, rules on mail or telephone order merchandise, rules relating to solicitations for franchises and business opportunities, and the mortgage advertising rule. Some of those, by the way, are rules which were just recently issued even after the Bureau published its proposed rule, and so it's taking over some of those new rules as well. And then there are a few RESPA and ILSA-related rules that they will be taking over enforcement of from the Department of Housing and Urban Development. Although the Dodd-Frank Act gave them the authority to take over enforcement and assume ownership, if you will, of some orders from other regulatory agencies, they elected not to. The second rulemaking, or I guess in this case really pre-rulemaking, is the defining who is a larger market participant for purposes of supervisory authority. The Dodd-Frank Act gave the Bureau supervisory power over banks and depository institutions and a number of other financial players, mortgage companies, payday lenders, and private education lenders. Only larger participants, and the Act didn't define what that meant, in other markets for consumer financial products or services. Under Dodd-Frank, the Bureau has to finalize its larger participant rule a year from today. It's not a substantive rule. It merely defines who will be supervised by the board in that area. In June, they issued a notice and request for comment seeking public input on issues that the board deemed relevant to defining who that is. The board did identify 6 markets for potential inclusion, and I think this is kind of a roadmap for where we're likely to see the Bureau rather, ultimately decide will be the areas they'll cover. They include debt collection, consumer reporting, consumer credit and related activities, money transmission activities and check cashing, prepaid cards, including gift cards, and debt relief services, debt management services. One fairly big pre-rulemaking activity that the Bureau has been engaged in is what they call know before you owe. And as you can see here, that this is actually copied from the Bureau's website, consumerfinance.gov. They use catchy graphics, catchy slogans, and they're really trying to get consumers involved through social media and giving feedback to the board on what kind of disclosures they want to see on home mortgage disclosures, this being the combined truth in lending and Redbud disclosure that's mandated by the Dodd-Frank Act. The goals that the Bureau has stated are clarity of the costs and risks to the consumer, the ability for the consumer to comparison shop for the best offer, and that will hinge on both the format and what is disclosed as well as the timing of the disclosure. The Federal Reserve Board had started rulemaking in this area, but it ceased it on February 1 of this year in anticipation of the transfer of authority. So pretty much shortly after that point, the Bureau really commenced work and has put out on its website and conducted consumer testing as well as roundtables with other regulators and industry participants since May. It has received over 13,000 comments on its first round of forms. The second round was recently completed. They're expecting a total of 5 rounds of public feedback before they will actually propose a single simplified combined TILA and RESPA form, which they'll publish in a proposed rule sometime before July of 2012. Just to show you optically what these look like, unfortunately, my crystal ball is a little cloudy today. I can't tell you what the final form is going to look like or what it's going to disclose. But here's the existing standard TILA disclosure and the existing RESPA good faith estimate disclosure. Here are the current prototypes that the Bureau has sent out for public comment. You can see that just optically, they are consumer friendly, or they believe that they are. They use a lot of highlighting and have much less content, but they believe more meaningful content. And here is the second one. They've given them catchy names like Dogwood and Redbud. The Bureau actually heat mapped the comments they've received so far on those model forms. And you can see from there where most of the comments that they've received have focused on and where they've had less on. And interestingly, most of them seem to be on the TILA part of that combined disclosure. Future rulemaking, certainly we can expect that now the Bureau is up and running, that they will take on rulemaking in many areas over the next years. We can anticipate that credit cards and open-end credit will be one area of focus. They recently published a report to Congress on the Credit Card Act and the effect that the Card Act had, as well as changes to Regulation Z on the credit card industry and on cost to consumer. And the Bureau believes that those changes were very favorable to consumers and has signaled that they may want to make further rule changes to Regulation Z and additional safe harbor form changes to make clarity and transparency and ability of consumers to compare terms even more easily available to consumers. There's also, I noticed this morning on the Bureau's website, a new credit card complaint form. So they are actively seeking consumers to squawk about their credit card issuers and on an online form submission. So it's clearly going to be an area of focus, not just in terms of rulemaking, but also enforcement. Fair credit reporting. The Dodd-Frank Act asked the Bureau to prepare, to do a study and prepare a report on variations among different types of credit scores, particularly differences between those sold to creditors and consumers. The Bureau published its report a couple days ago, and also the Bureau published a report also mandated by Dodd-Frank yesterday on the use of remittance histories and their relation to credit scores, and the transparency and consumer understandability of remittance exchange rates. Those are two other areas, credit scoring and remittance exchanges, that I think we also can safely say that the Bureau will be looking at in terms of future rulemaking. And they've signaled that they have some recommendations, particularly in the remittance history report. That wraps up my portion of the material, so I'll hand it back to Mike. Thank you.
Thanks, Tim. Thank everyone for their participation today. Any questions not covered in today's discussion we'll address by email follow-up within the next few days. We plan to have another one of these programs on the Consumer Financial Protection Bureau and its evolution, and we hope you can join us for that. We don't have a date yet. But you'll certainly get the announcement when it's ready. In the meantime, please take a moment to complete the brief survey that appears on your screen. We appreciate your participation and hope you will join us for our next program. Thanks, everybody.
Ladies and gentlemen, this does conclude today's